So I'm going to give you basically a IP-ish patent law course in 45 minutes that I usually teach over 14 weeks. This may be more advanced than some of you know, and it may be sort of easy for some of you who've sort of been in the patenting space for a bit. And so it's kind of directed in the middle a little bit. And I'm happy to take questions while I'm going through it, or if you want to wait till the end, it's really up to you. All right, so what is intellectual property? So you'll see a bunch of these words thrown around: patents, trademarks, copyrights, trade secrets. And then we often bundle in there what we might call generally in contracts know-how, which is sort of anything else that you think is sort of something that you've come up with that doesn't fit into these other categories. So patents cover useful inventions, copyrights cover creative expression, trademarks cover origin, brand, source. Trade secrets cover secret information. And then know-how is kind of all the other stuff that isn't really protectable in these other ways that we think of legally. Right, so I'll start with trademarks because they're sort of the more basic sort of area. Trademark lawyers hate when you say that, but it is in fact true. A little bit easier to understand because we're all familiar with brands and logos. They're really source identifiers, things that signal information. So you can sort of quickly see a logo, quickly see some trade dress, and sort of associate that to source. We think of protection there in terms of the range of distinctiveness. And so if you want to use a word that's like shoe for your shoes that you're making, that's not really going to signal source very well, and that's going to be a very, very weak trademark, if at all, and so you'll have to build some distinctiveness in there with how you're presenting your particular brand. And then other things that are more whimsical, like Zumba or Apple for computers, those are the sorts of things that might carry inherent distinctiveness that would give us stronger protection and ability to protect others from confusing with your particular source information. We also protect trade dress and product design, so things like the Coca-Cola bottle shape. Those sorts of things are generally protectable if you've built in some distinctiveness and your own source connected with it. Sort of takes some build-up over time. So typically we think of trademarks as gaining protection from use in commerce. And so for federal registration, that means using it in interstate commerce, sort of tied to the Commerce Clause in the Constitution. That's registering it, using it in interstate commerce, having an intent to use is one way to get down the path of registration. And then we give nationwide rights to federal registration, but it's important to remember that trademarks also carry geographic common law protection, and so you might not have a federal registration but still have rights in your use area, and that's a very important part of trademark law as well. How do we determine whether someone is infringing on your trademark rights? Are they confusing to you? And so the question will be put before a court: is there some likelihood of confusion that people will buy this other thing instead of yours? Confusing source. You won't always want to think of trademarks as origin of source, signaling information, shortcuts for consumers. There are also some other doctrines that will allow trademark owners to prevent what we call dilution or tarnishment of brands. And so we might say that a very large trademark owner like Amex or Visa will be able to shut down someone who might be using that mark for something that's not quite confusing to their brand, but that is sort of diluting their signaling information with their particular trademarks. Same for tarnishment. So if you, there's a case involving Victoria's Secret and some other sorts of brands that compete with them in a even more risky way. And so we sort of worked out how we might think of when you're using a signaling of source that will in fact tarnish the brand owner and what that looks like in litigation. Patents and copyrights, as compared to trademarks, flow through a constitutional provision. And so in our Constitution, we give Congress the power to promote progress in science and the useful arts by giving, for limited times, rights to authors and inventors. All right, so that's the basis for both patent law and copyright law. They're very different, and they protect very different things, and I'll quickly talk about copyright, and then I'll move on to patents, which I think is where most of you are sort of thinking about where your IP rights may lie. Right, so copyrights are protectable if it's an original work that is fixed in a tangible form. So it must be fixed. It must be some expression in a tangible medium. And that's included in these categories: literary works, musical works, dramatic performances, pantomimes, sculptures, architectural works, so everything that you sort of see there, including sound recordings. You sort of identify the category and you register it with the Copyright Office, although the copyright vests and is created the minute that you fix your tangible medium, right? The minute you put your expression. The rights that you get with copyright, there are 6 rights. The right to copy, the right to reproduce, the right to prepare derivative works, so works based on your right, the right to distribute copies, the right to perform publicly, the right to display publicly, and the right to perform sound recordings publicly by means of digital audio transmission. So you can imagine which one of those was added in the past century or so. All right, the duration for copyright is 70 years plus the life of the author for individual works. And if it's a work that's been created by a corporation or is anonymous, or an orphan work where we've sort of detached from the author, we're not sure who the author is, then 95 years from its publication or 120 years from its creation, whichever expires first. So copyrights last a very long time comparatively to patents. Trademarks, I should have mentioned, last as long as you're using them. So might be forever if you continue to use them and you continue to maintain that connection to the source signaling. Copyrights and patents, because of the constitutional limit 2 times, have durations. Copyrights is relatively long. Patents are a little bit shorter. All right, patents. Yay, my favorite part. All right, so what do patents do legally? Right? They have claims that define the scope of an inventor's right to exclude others from doing some things. And those legal rights include the right to make, use, sell, offer for sale, or import into the U.S. and its territories the patented invention. Patents are treated like personal property rights, so we often think of them like we think of land. And the claims in a patent stake out what your patentable invention is and what you can exclude other people from doing. Right? It's a negative right to exclude others from doing those things: making, using, selling, offering for sale, importing into the U.S. What is patentable? Right? So patents claim useful, novel, not obvious inventions that are properly disclosed to the public and that comprise a subject matter eligible for patenting. So when we think of patentability, it's bound up in those notions of utility, novelty, non-obviousness, and patent-eligible subject matter. And those are sort of the big parts of what you're thinking about when you sit down with your invention and think through what your patent application might look like and what the rights you're trying to secure will be. Right, so what's patent-eligible subject matter? Everything under the sun made by man or woman, or more common term, but not an abstract method, not a natural law, not a physical or natural phenomena. Right, so we've had a few cases that have run through the Supreme Court in the past few years that many of you probably have sort of seen in the news or sort of touched on in some way as you're sort of working through the work that you're doing. And so Myriad Genetics, a big company around here, was part of a big Supreme Court case looking at isolated genomic DNA and whether that was patent-eligible subject matter. And it was found not to be, that isolated genomic DNA is not patent-eligible subject matter because it is the same exact information that you would get in the actual genomic DNA found inside the cell. cDNA, the court said in sort of a throwaway footnote, may be patentable because of the arrangements that are made when you're sort of doing the deletions of some of those pieces. And that's because isolated genomic DNA is a natural phenomenon, is what the court would say. Mayo versus Prometheus is another case looking at diagnostic methods. That method was not patentable because it was a natural law. It sort of measured how some medicine acted in your bloodstream and reported that back out to a doctor. That process was allegedly patent eligible, and the court said, no, there's not enough there that's inventive to tell us that it deserves the exclusive rights of patenting. And then Alice versus CLS Bank is a computer method case where the court explained a little bit more about how an abstract idea would not be patentable. So I think it's easy for us to say that if I file a patent application claiming 2 + 2 = 4, that's not going to be patent eligible. But very complex computer algorithms or routines that you're running through software might look very different from 2 + 2, but they're simply things that are sort of being run quickly on a computer that could sort of be done by folks outside of the computer space, and figuring out how much more you need to add to drag your software routines into patent eligible subject matter. It's kind of an open question currently in sort of the legal sphere. And so we often say that software is probably patentable depending on what you're doing, and so that's kind of a tough space to kind of be operating in right now. That would also apply to apps as well, right? Thinking through what your app does, and does it add enough to say that it's not just an abstract idea, but something that would be patent eligible subject matter. Right, so when you think of patenting, right, you often think of patenting to gain some commercialization, right? So these are some examples of subject matter eligible categories and things where we've clearly said that these things are patent eligible. Compositions of matter, that includes your really routine pharmaceuticals, things like fuels and fuel additives, any sorts of composition of matter. Machines and manufacturers is another general statutory category. That sort of captures all the things that you would imagine fit into that category, right? Drones, remote monitoring devices, prosthetics. And then methods, another space where we've had those questions about abstract ideas in the software space. There are lots of other methods that are more clearly patent eligible. CRISPR gene editing is a really common example right now, sort of working through the priority disputes related to that inventive technology. Water purification systems, we sort of run through some of that environmental stuff up at the law school. And complex software routines, sometimes sort of bracketing that, thinking through what that eligibility question looks like after Alice. Your patent application has to provide an adequate disclosure in order for you to get back out exclusive rights. So your disclosure document, what we often call in the vernacular your patent application, has to adequately support your claimed invention. And that comes in generally 3 parts. One is what we call a written description of your invention. The other is that you have enabled a skilled artisan to make and use your invention. And then you need to include claims. So you need to particularly point out and distinctly claim your invention. Your disclosure is doing 2 things. One is that it's educating the public, and it's sort of that trade-off, the quid pro quo, although that phrase is now horrible to use, said them in contracts class too, giving the public information about your technology and getting back from the government the exclusive rights bound up in your property in the patent, right? So telling the public what your invention is and getting some exclusive rights and protection bound up in them. The other thing that your disclosure document does is that it sets the scope of your rights. So all of the information in your application has to be commensurable with the scope of what you're claiming. And so you can't overclaim if you haven't provided enough information in the disclosure document to tell us what your technology does and how it works. So it's staking a claim, right? Setting out your exclusive rights, setting the scope of your claim, and then also educating the public as to what your technology does, giving the public that information, promoting progress, tying it back to the constitutional provisions. All right, so enablement, enabling a person having ordinary skill in the art or a skilled artisan to make and use your invention without undue experimentation. So enough information in your disclosure document so that someone of average skill in your art, not an expert and not someone who's just entered it, to pick up your disclosure document and be able to reproduce your invention without undue experimentation. And that's going to sort of depend on what your technology art unit looks like, right? What kind of space you're operating in. Is it ballpoint pens or is it CRISPR, right? It's going to be very different levels of skill in the art and what undue experimentation means. Written description is that the inventor has conveyed to a skilled artisan that they've invented the invention, that you have possession of the invention. Typically, written description and enablement rise and fall together. The words that you use in your disclosure kind of cover all of those bases together. There are some outlier cases. Often, more recently, they've been sort of in the biotech space. So when you might try to identify DNA solely by function, we might say you're not in possession of the invention. You haven't given us enough information to say that you've claimed the whole thing. Maybe you could say you're in possession of a genus by identifying just a couple of species. That's going to be very technology dependent, right? Your adequate disclosure and whether in fact it meets our requirements of Section 112, patentability, will very much depend on the technology you're working on, the words you're using, the description that you've provided. Novelty, sort of what it sounds like. So before your filing date, the invention must be not known or used by others, not on sale, not in public use, not patented by someone else or you, not described in a printed publication, not otherwise available to the public, and not stolen from someone else. And this seems like relatively logical, right? But it's kind of nuanced into how we figure out these questions of public accessibility and what we mean by otherwise available to the public. And there's a lot of rich case law that tell us something about that. And it's really important for you as inventors who might be facing things like a public disclosure event or going to a conference where you're presenting a poster and standing around a poster session, thinking through what that means in terms of giving your information to the public such that you might be preventing yourself from obtaining patent protection. So a single reference has to disclose each and every piece of your legal right of your claim. So if the claim is to X and B connected by Y, your reference has to disclose X connected to B with Y. Novelty is a very rigorous determination based on one disclosure event, whether it's a printed publication, a patent, a poster, something else that's gotten out into the public domain. You might have heard that the US has a grace period. It's better to call that a limited grace period. And so if you as an inventor make a public disclosure, that will protect you for a year from any intervening prior art that might arise in that meantime. This is United States law. This doesn't typically apply in many of the other countries that you might be seeking patent protection in. And so if you are going to proceed with a public disclosure and rely on that limited grace period, you want to think very carefully about foreclosing any international patenting ability that you might have by doing so. And so that's a very, very careful space that you want to navigate. What do we think about in terms of secrecy and restriction? It's really about what the inventor is doing and protecting in terms of preventing public accessibility. All right, so one of our very old, very comical cases involved some corset stays. So basically underwear that was always worn under top clothing, but we found that to be in the public domain. A disclosure had been made even when the inventor's lady friend had worn the underwear around because he had put no restriction on the invention. He had not told her not to show anyone her underwear. It's a very awkward case. And the way that we solve this problem typically is to use a non-disclosure agreement. So you enter into a contract with anyone who might be getting the details of your invention and then use that contract to point out that you have not made a public disclosure, but you've wrapped up the information exchange with contractual protection and secrecy, and so it's not in fact meaningfully been delivered to the public. If the inventor takes no steps to protect that kind of public accessibility, then we'll say that the invention has been disclosed. right? So Klopfenstein is another case involving a poster presentation, an abstract that's been put out into a very, very large conference, as many of us sort of have been to, sort of walking through the halls of the posters. That might trigger a public disclosure if there's enough information on that poster or in your presentation at the conference for someone to backtrack to what you're trying to claim. And so you want to be very careful about those kinds of disclosures as well. We're all sort of pressured to do them in the academic space. But if you're thinking about protecting your invention and entering into patenting, you want to be very careful about maybe filing a provisional or talking to the TVC or thinking through what your patent strategy might be before you enter into one of those disclosures. Another patentability requirement is even if it is novel, right, even if we haven't found one single disclosure that will disclose the entire thing you're trying to claim, we might not allow patenting if it's close to that. And the way that we frame that in the patent statutes is the concept of non-obviousness. So even if it is novel, we will say if it's a little bit different from what's out there, or it's obvious to a skilled artisan, you won't get exclusive rights. So would a skilled artisan in your field come up with this invention just prior to your filing date, given his expertise, sort of an average expert in your field, some average creativity, and given perfect knowledge of all of your prior art searches? And so we sort of create this hypothetical inventor in a room with all of the prior art that you might find with our wonderful Marriott librarians who are going to show you how to do prior art searches later. Prior art will include all references in this field and all references relating to the problem to be solved. And so it might be, there's a case that we read in patent law involving a clamshell laptop. And a lot of the references involved computers that were able to be hinged, but a couple of the references were just hinges. And so those are things that solve the problem, but they're sort of coupled with other things in the field. And that might render an invention obvious. Right, so another case that we sort of read is thinking through a safety lighter. Is that a combination of a non-safety lighter, which they actually sold these before they developed the safety version of it, a safety locking mechanism, with the old school lighter that has a sort of locking mechanism but not in the same way, right? So thinking about whether you would put that together. Some of the questions that we ask as we're trying to figure out this legal question of obviousness is whether there's been a long felt need and failure by others in the art. So even if it might be obvious to me today to have a safety lighter, if people had tried to put these things together and couldn't do it, that might tell us something about my invention not being obvious. Or commercial success. So if you can tie extreme commercial success to the patentable features of your invention, then we might say that tells us something about it being not obvious. And those are the sorts of things that courts will grapple with as they try to figure out whether you've gotten far enough afield from what a skilled artisan might have come to in that room with all of the prior art. All right, just a few words on invention and inventorship. I have to say, in sort of working with some of the bench to bedside teams, this is the question that kind of keeps coming up for the most part. Who is an inventor and what do we mean by inventorship, and how does that translate to who owns the actual patent that might arise, the property right? So conception is when the idea is so clearly defined in the inventor's mind that it would only take routine practice to get the invention to working, right? To build a prototype. We don't really require anything other than sort of routine action in the technology. Any person who contributes to the conception of a single claim in a patent application is an inventor. That might be a lot of people working on a team. That might be just one person working on a large team. And so oftentimes what we see in the bench to bedside space is that we have a team of a bunch of people and they want everyone to be on the patent application, but we only have one of those people has contributed to the conception of all of the claims in the application. Or we might have the reverse, where we have one person who wants to be the sole inventor, but in fact 5 or 6 other people have contributed to the conception of some of the potential claims in that application. And so inventorship is a legal question. It's really important to get it right and sort of talk to someone like at the TVC or the General Counsel's office to kind of figure out what that looks like for particular teams. It's not people that you would put on your publication for Science or Nature. That's a very different group of people, and this is a really important legal question. Reduction of practice is another sort of term of art in this space. File a patent application, that is your reduction of practice. If you haven't filed a patent application, you might have an earlier reduction of practice where you establish the invention works for its intended purpose. That can be very important in some old patent applications, becoming less important now that we've moved to determining inventorship by filing date and not sort of backing it to invention date. But it's still going to be a very important term of art to combine into who is an inventor. Reducing the invention to practice is not the same as conceiving of a claim, and it's conception that we tie inventorship to. Ownership is tied to inventorship. So ownership vests in the people who are inventors. Those inventors can assign their rights to anyone that they choose. Ownership does not vest in an employer. So simply because you work for the university or you work for IBM does not mean that when you invent something, even within the course and scope of your employment, does your employer own it? And that's a really important piece of the inventorship ownership divide. Joint inventors own equal, undivided interests in the entire patent. And that's another very powerful tool for joint inventors. Yes?
It seems like the employer feels like they own it.
Don't they always, though? Yes, so the way that they solve this problem is they ask you to enter into a contract where you assign it to them, which you've probably already entered into if you work for the university. Exactly, yeah. The important thing to remember is they have to do that to get ownership from you, to own your invention. If they don't enter into a contract, you as the person, the inventor, will have title to the patent, and they will not have any rights to it at all. Yeah.
So it's a little bit on the sideline from this class, but that seems like an HR thing rather than a council thing. That's kind of almost like they send you that thing, you sign it and give it back rather than having a discussion over it.
Does anybody have a discussion over it? I just signed it and sent it back.
So it means that's what my problem is. I wanted to, but then I got busy and I'm like, well, I've signed it already.
Yeah, I guess I'm not quite sure what you mean by an HR issue. It does come from HR, but you are assigning to the university. And I imagine that if you're in a very inventive space, that they could say that they won't hire you unless you enter into the ownership agreement, the assignment agreement.
But you're saying it's optional?
It's always optional. I mean, it's optional to work here, right? For some of us, I guess. I signed it because I like my job, but I'm not an inventor. Yeah.
One thing that I have seen is I have a few colleagues who had invented something either kind of in the in-between space between jobs, or that had something that they had been meaning to work on and never had quite, that they did carve out before starting an employment. So
they're able
kind
to
of a
negotiate.
pre-existing invention that they didn't want to necessarily assign to the new employer. I have had a couple of colleagues carve out and say, yes, I'm beholden to the university policy except for this thing which I had before I worked for you.
Yeah, you could always make that especially if you invented it before you started your employment, that can be very clean. If it's something that's sort of ongoing, you'll probably want to negotiate with the person who's forcing you into the contract and ask for a carve out or a rider or something.
If it's really closely aligned with what you do for work, they're going to want that as an employee agreement.
That's accurate, yeah. Joint inventors can unilaterally license exclusively or not. And so that's why it can be very powerful to be a joint inventor. You have a lot of power in which you can license out your other joint inventors without asking them for permission or giving them any of the royalties that you might make off of that. And so you want to be very careful about what your legal organization might be, and this is why we see a lot of patent holding companies and LLCs that might take control of the patent so they can speak on behalf of all of the joint inventors, and the joint inventors have sort of decided what their arrangements look like in terms of royalty streams or sharing equity and that sort of thing, and who has the power to sort of dictate who can license and whatnot. And then all owners have to be joined in an infringement action. So if one of your joint inventors refuses to join the infringement action, it can't move forward. And that prevents your ability to enforce your exclusive rights, which is really just the value that you have in your patent, right, for the most part. Right, so employee invention, we sort of just talked on this. So most of us are general employees. Even if we invent something within the scope of our employment, it is owned by us as people as a default rule. And to change that rule, our employer has to have us enter into employment contracts that change the ownership stream of that. And typically those employment contracts give us back something like a royalty or some kind of flat payment or an agreement to pay for the prosecution, and we'll kind of continue to work in some kind of joint arrangement. There are a very small number of employees who are hired to invent specific things. Not like I'm hired to work in a lab and anything that's sort of generated there, that's a general employee, but where the company has laid out what the invention is meant to be and what it's meant to do. Those are called inventive employees, and those are obligated without a contract to assign their inventions to their employer. No university employee is typically an inventive employee. We're almost all general employees, and so we're wrapped up in employment obligations that look a lot like this. And so typically they come in two flavors. Agree to assign inventions related to my employment, which typically means as I invent, I then assign. And then the second version, which we have totally moved to here at the university, is I will assign, and today I assign anything that I might invent in the future. And then the university owns all of them, creates a legal right on the day you enter into the agreement, doesn't have to wait until you invent something. That's a much stronger contractual right for the employer, and so that's typically what most employers have moved to. What does it mean to have exclusive rights? Well, they're only as valuable as your willingness to enforce them, and you enforce them as you do with trademarks and copyrights and what we call infringement actions. So a patent claim can be infringed literally or by some equivalent. So you get the literal scope of your claim, and then you get a little bit of a, what I call with my students, a fairness zone. So where people might just make a small change to kind of get around infringement, we might say that you still infringe by doctrine of equivalence rather than literal infringement. That's sometimes sort of an uphill sledding in a litigation. And then we also have what we call secondary liability in the law, where you might be a party who actively induces somebody else to infringe. You're still going to be on the hook for damages, and you might contribute to someone else's infringement. So for example, you might supply a specially made part for someone else building a machine. You're going to be liable for contributory infringement if we sort of meet the elements of that. You have to know about the patent. You have to have some intent to do this behavior. And so it's really just a way to map over liability when the direct infringer is somebody like you or I or my mom, a consumer, and we'd like to really get the manufacturer of those products and kind of figure out how we might capture some of that harm to the patent owner by the person with deep pockets and not you and I as consumers. Remedies for infringement look like cash or injunctions. And so the cash part looks like either lost profits. So we might think about what the market would look like but for the infringement, and what sales would you, the patent owner, have made if the infringement had not occurred. That can be very complicated. It might be very uncertain if you're in a very new startup type venture. And so at a very minimum, our statute allows for you to get what we call a reasonable royalty. So if you're unable to prove lost profits, if you're unable to create this hypothetical world without the infringement, we would say you would get a minimum amount in the litigation in terms of money award that would look like a hypothetical negotiation between the patent owner and the infringer. The moment before the infringer starts infringing, what license rate would they come to? Sort of presuming that the patent is valid and presuming that the infringer wants to infringe. And so we'll set that rate as a payment out if we find liability for infringement. The bigger threat in a litigation is the threat of an injunction. And so your exclusive rights as a patent enable you as a patent owner to seek to shut down others from doing the things, right? From making, using, selling, offering for sale, or importing into the US the patented invention. And it's that threat of injunction that can often get you to have an infringer either start paying you a royalty, enter into a license, settle out a litigation before you get to the actual jury trial. And so that injunctive relief is very, very valuable in the patent space, in addition to the money damages. You can also, by statute, achieve treble damages for infringement if we think the infringement has been particularly bad, or what we call egregious acts. And you can also get attorney's fees and costs in exceptional cases, and that, for those of you, presumably many of you, haven't gone to law school, that's unusual here in America. Most of the time people just pay their own way in litigation, but in the patent space we allow for attorney's fees and costs if it's an exceptional case. You've probably heard the term provisional applications. So provisional applications allow you to obtain a filing date if your submission meets all of those requirements that I just told you about, right? Is it patent eligible subject matter? Have I enabled a skilled artisan? Have I provided a written description? Do I have particular claims? And is it novel and not obvious? That allows you to get a filing date. It allows you to then make public disclosures without worrying about unraveling your patentability for any of those patentability questions. But provisional applications are not examined by the patent office. They're a placeholder. So they get you a year. We often file them here. Those are the things that we file on behalf of Bench to Bedside because they're very inexpensive to file fee-wise at the patent office. So I think it's currently $70 to file a provisional application if you're a small entity or micro entity. They expire after a year, so you have to either convert them into a non-provisional or file a non-provisional that claims priority to them, or file a patent cooperation treaty application related to them to continue forward and have some examinations done in that manner. We typically try to draft our provisional applications to look like non-provisionals, to have as much information as possible to try to get as good of a filing date as we can for what might be mapped out later. But you're always going to be sort of wondering if you're filing too early, if you don't have enough information to enable a skilled artisan to establish a written description, you might not get that earlier date for the later claims that you might file. So that's kind of a sort of pushing you against trying to file too early, and that's a really important thing to keep in mind. Non-provisional applications come in 3 flavors, and utility is going to be the bulk of what we do in the commercialization space. It's utility application. It's directed toward what things do, and those have the longest term. Design patents reach just ornamental features, and so you've seen these for shoes. They sort of reach like laptop looks, different sort of ornamental features on things. I've seen applications for like Sharpie pens. Plants have a bunch of different kinds of rules for how those work. They relate just to basically varietals of plants. Once you file a non-provisional application, they are examined and they work through the patent office. They're assigned to an examiner. The examiner will take a look at all the prior art that you've cited. They'll take a look at your application. They'll issue what we call office actions. You'll have a back and forth with the office, with you or your patent attorney. And then eventually, you will get some claims issued, and that is your legal right as a patent once your patent issues and you get a patent number. Your patent term is 20 years from your effective filing date. Applications might claim priority to other applications earlier in time. You will be tracked back to your earliest effective filing date that has an adequate disclosure, enablement, written description, particularly pointing out and claiming your invention. There is the ability to get a patent term adjustment. And so if the PTO delays your file for an egregious amount of time, you can petition them to give you some days back on your patent term. More typically, patent term adjustments are awarded when your invention that has been stuck at the FDA for a long time, you're sort of waiting for approval. The patent office will give you back some patent term adjustment days to account for that delay as well. The Patent Cooperation Treaty is a way that you might enter national stages and get international patenting. Patent rights, whether it's US or any other country, are national and territorial. So a US patent only gives you rights within the US and its territories. Patents from Japan, same, right, only within Japan and its territories. The Patent Cooperation Treaty, or what we call PCT applications, streamline that process and allow you to get national protection, but you still have to file in those countries as part of that process. And so you have to, what we call, enter the national stage in the countries that you want to seek patent protection in. That can be crazy expensive. The common application will save you a lot of time, money, and effort on the front end. You'll get a search report and a written opinion from the World Intellectual Property Organization. That'll help you make a lot of important decisions about whether you might want to enter the national stage at different countries. But you still have to enter the national stage. That means engaging with local attorneys in different patent offices in all the countries that you're seeking to obtain patent protection. You'll have to get translations for countries that don't operate in English, and that can sort of add up fees in private practice. Not every company who sort of thought that it had a winning idea was going to go down this path. It was very, very expensive. All right, so that's my 14-semester course in I don't even know how many minutes that was, but I'm happy to entertain any questions here. Feel free to contact me at that information if you have questions down the road. Yes?
Thank you for the talk. Can you distinguish small and micro entity? There's some clause for personal income too, right? Or is it based on the income of what might be a company?
Yeah, one is personal income, and I think it's right now it's $120,000. The other version is that you are part of the university. So all the ones that we file for bench to bedside are typically that second version, microentity. So it's sort of part of students, university folks. It's really when we have an outside inventor who might be not affiliated with the university where we're thinking through what the personal income looks like. But it's a dual track.
So it'll be all microentity, you're saying?
We have only once in 5 years working with bench to bedside filed a small entity, which would be the next step up. Yeah.
Can you talk a little bit about freedom to operate?
Yeah. Freedom to operate is really important, and it means that you are not infringing anybody else's patents. So if you are engaging in invention and design, and you're thinking about commercialization, you want to do a very good prior art search, both for protecting yourself in the patent space, but also learning what that landscape looks like in terms of what's patented by others. And so if you find something that sort of reads on what you plan to do, you either have to design around, sort of avoid what is claimed in those particular patents, or go down a much more expensive path of figuring out whether those patents are invalid or not. that answer your question?
A little bit, but there's a difference between patentability. So you can have claims that are already patented, but they're not, they don't provide the exercise to commercialize, right? Because it's patentable, but it's not usable for fields to operate.
That is accurate. So we might call that a blocking patent situation. So patents are only a negative right to exclude others. So I might get a relatively broad patent. I'm the first person to arrive in this field, sort of a pioneer, as we might say, very broad claims. Someone else comes along who develops some bells and whistles to what I've invented. They patent their thing with the bells and whistles, much fancier chair than my chair. I, as the pioneer inventor, might not be able to create the fancier version, and they might not be able to create my plain version. They can't sort of sell their bells and whistles because I own the basics. And so typically that arrangement forces those people to talk to one another and enter into some kind of agreement, right? A license or settlement or something. So that's the possibility. That comes about because there are only rights to exclude others. So it may be that what you have is a really amazing commercializable idea. It's patentable because it's new and it's not obvious, but it may also be covered by someone else's patent. And it may be that someone else's patent only covers maybe just the back of this chair, and you want to patent maybe the seat, but that's kind of how that might work.
Thanks.
Other questions? Yeah.
So you said something about each co-inventor would have to sign on to an infringement case. Wouldn't that give each co-inventor, so much power that a competitor could buy off one of the individuals? I mean,
it happens relatively frequently is probably not the right word, but one of the cases that I teach in patent law involves two competing surgical companies that did that exact same thing. Found an unidentified joint inventor, had the court add that person as a joint inventor using the legal conception idea, and then bought that person out, and then never had to pay any royalties for infringement. The way that you can solve that problem is either have a patent holding company or an LLC or something that sort of wraps up the rights together in one entity, or you can enter into a pre-litigation agreement where you give the rights to some person to take the infringement action forward. So basically opting out of being in the infringement action. And then we can't force you to be in it using our civil rules of civil procedure, but contractually we'll say you could give that right away.